Anyway, I feel kind of bad because I feel like it should be there. But
Oh, I think they should.
I think it's more than here. No.
Yeah.
Anyway. Because Tom was always like, you know, the personification of the judge.
Absolutely.
No, I asked the judge. I am, and I don't know either.
Oh, how about that?
Way harder.
You just made things happen.
I was like,
Poked around.
Idiot.
Oh, yeah. Have you logged in?
I'll give the baby up the sign-up sheets. Huh?
I can't get through this one.
So sign up.
We've got more about.
Adverse possession. It's like, because the language is like,
Is it old English?
like 18, early 19.
Not so just, it doesn't make sense. It just like, it doesn't seem fair.
Oh, no, it doesn't.
I didn't read, I mean, it's not lost.
Yeah, they
Talking about, man. Yeah.
But they make it interesting, right?
Yeah. What? There's snacks I didn't see. Give them away.
All right, you guys ready? No pressure on you guys, but if we hustle tonight, we might be able to get out here early. And make me very happy. I need to be in Victorville by 8:30 tomorrow.
That's really early.
So,
Bad enough getting to India by 8:30.
you know, I'm not looking forward to it, the early morning drive, but, you know, that's what comes with the territory, right? Okay, so the most basic rule, right, of evidence is it's got to be relevant to the case. It's got to be relevant to an issue in the case, okay? And how do we know if something is relevant? If it has any tendency to make a fact more or less probable than it would be without the evidence, and that fact is of consequence in determining the action. Okay? So, two parts to your 401 rule statement that need to be there. Right? It's got to be a fact of consequence, and the evidence must make that fact more or less probable. Doesn't matter which direction it points, but it's just got to point one direction. Okay, this is the lowest standard you're going to have, right? Just about anything can be made relevant if you think really hard about it. Okay, so this just as a basic rule, this is the first hurdle you've got to jump over before any piece of evidence comes in. Okay, so it's got to be it's got to go towards a fact of consequence. It's got to make that fact more or less probable. it does that, it's relevant. Doesn't mean it's admissible, it means it's relevant. Okay, so, anybody want to share their rule statement that they wrote out? You're all going to do it, but it's just something, hey, anybody want to
Who's
share?
going to go first? Okay. All right.
Alright, so for 401, I have, evidence is relevant if it makes a fact more likely to be true or less likely to be true than it would be without the evidence, and the fact of importance, and the fact is of importance in determining the outcome of the case.
A little wordy.
Okay, yeah, it's, that hits everything,
Yeah.
but is that something you're going to remember, slap down, and then get into your analysis? Right, we want your relevancy statement to just flow.
It's definitely accurate though.
Right.
Okay, if you can remember that,
I just wrote it in a way that made sense to me.
Yeah.
right,
But yeah, I know what you're saying. I can try to wiggle it down a little bit more. Do you want my 403 too, or you want to wait?
we'll get there.
There you go. Anybody else?
All right, what do you got?
To be honest, I looked at it and I said, can I change it any better than this? And I just stuck with it. So I just memorized
With the
it.
actual language of the statute
Yeah,
itself?
I just memorized it.
Okay.
Okay. Anybody else?
I just made a note here to edit it because I took off the last part of the first where it says evidence is relevant if it makes a fact more or less probable, but
Okay.
I'm not sure. Yeah, I didn't put the and.
Yeah. The end is really, and that fact matters.
Yeah, and the fact is a consequence of determining the action.
Right.
So ultimately, right, these two parts, right, if you're talking about facts, multiple places, put them together, right? A piece of evidence is relevant, and it's got to be clear to you guys. We're talking about evidence. Sometimes these rule statements say a fact is relevant if it makes a fact of consequence more or less probable, right? It's not the piece of evidence. Remember, evidence is testimony, it's pictures, it's video, it's demonstrative, it's whatever.
Physical.
Does the evidence make a fact of consequence more or less probable? That's when something's relevant. Okay?
And notice that it doesn't have to be really powerful. It can just make it more or less likely, just a little, right? And the fact of consequence doesn't have to be really, really important. It just has to matter somehow.
Just what you got.
I have, evidence is relevant, it has a tendency to prove or disprove a fact of consequence.
Perfect. Right, now see, you changed the language a little bit, tendency to prove or disprove. I like that because that's similar to California's, right? California says it does, evidence is relevant, it has any tendency and reason, right? That's the language of the California tendency and reason, right? Because we got to be more wordy than the federal rules.
For California, you can join us.
Come on in.
Okay, one more.
Ms. Isabel? Oh, Clara? I'm sorry.
Well, I kind of broke it up by what Fleming's have put in there. So I have the evidence is relevant if the fact of consequences in determining the action kind of makes sense to me. And the fact more or less probable than it would be without the evidence.
Sort of switch it around.
I switched it around.
Mhm.
Okay. All right.
Yeah, that's the two parts of
Those are the
one.
Okay.
Okay, so really, now's the time to figure out how you want to write your rule statement, commit it to memory, and you're going to use it the rest of the semester. Okay,
Just maybe the rest of your career.
so just having a relevancy rule statement down pat, those are the two big issues. Okay, 402, you're never really going to use. Just know that it's there, right? Relevant evidence is admissible unless any of the following provide otherwise. right? U.S. Constitution, federal statute, these rules, which are the federal rules, or other rules prescribed by the Supreme Court, and irrelevant evidence is not admissible. So 402 basically says, look, relevant evidence gets to come in unless something says it doesn't come in, right? And of course, irrelevant evidence is not admissible. So irrelevant evidence gets excluded pursuant to 402. It also would be excluded pursuant to 401 because if it's not relevant, it's not going to come in. It is would thus be irrelevant. But what 402 also does, it kind of creates this presumption that relevant evidence is admissible. Okay, and then it gives you this narrowing of it that says there may be other areas that says it doesn't come in. It might be relevant, but it's not going to be admissible under these rules or under the U.S. Constitution or federal statute, right? Somebody confesses to a crime, that relevant? Absolutely, right? But if it was not given voluntarily, well, the Constitution says it's not admissible, right? These rules have hearsay rules, like would it be admissible would it be relevant that somebody said, you know, hey, this is what I saw happen, and somebody else comes in and says, hey, that's what that person said they saw happen. It's probably going to be relevant to the issue at hand, but hearsay may say it doesn't come in. Okay, so 402 lays out how relevant evidence is inadmissible while giving you a presumption for admissibility as well as an exclusion of irrelevant evidence. You're really not going to cite to it much, okay? But just know that it's there, just so you have that basic understanding. So why don't we go through some examples of relevancy before we get to 403? We'll get to 403. But before we get there, why don't we take a look at 3-4 in the book. All right, we're on page 51. We'll just go through these and we'll discuss them. Okay, Eddie from Boston is accused of robbing the First City Bank of Massachusetts, and is alleged to have used a Saturday night special revolver during the robbery. Which of the following items of evidence would be relevant to the prosecution case and explain using inference chains? So inference chains are when there's a fact that's out there and you draw a conclusion based on that fact. Okay, you draw an inference and sometimes multiple inferences from that. You might be able to give a better example because you're so familiar with the jury instructions that you've read 1,000 times.
I don't know, but you can draw an inference by saying, okay, it's sort of like circumstantial evidence, right? Something that you can draw an inference from that is more likely or not that something happened. So if you see somebody walk into the law school wearing a raincoat covered with water, you could draw an inference that it's raining outside. Of course, it's India, so you can probably also draw an inference that a pipe's broken. Right? So the fact would be, you know, Judge Hopp walked into the law school wearing a raincoat covered with water. The inference is it's raining outside. Right?
Makes sense? Okay, so number one.
And remember, we're looking at this from the prosecution's case.
Okay, Eddie withdrew money at the same bank the day prior to the robbery after having a friendly 10-minute conversation with the teller. No one else was in line. that relevant to whether he robbed the bank on the?
And try to answer this in a, it tends to prove or disprove a fact of consequence, right? So what is this? And it's, you know, it's a couple of facts here. But what does this tend to prove or disprove about the crime? Anybody?
Well,
Come on.
well, it may be probable that he was trying to extract information from this teller regarding the schedule of individuals working at a certain hour.
Okay, we don't know what the conversation was about.
Right.
And you probably don't have to go to that level of detail to try to figure out why this might be relevant.
But you're on the right track, right? You're the prosecutor, you call a witness in, and that witness is gonna say, this guy was in the bank the day before, and I had a friendly conversation with him that lasted about 10 minutes. There was nobody else in line.
People who rob banks sometimes case the joint, right? Check it out. See how many security guards are there. Who's where, right? Maybe talk so this could be relevant to the prosecution's case because it tends to prove that Eddie robbed the bank because he cased the joint the day before. Or it could be relevant to the prosecution's case because it would show that he didn't rob the bank, because people who rob the bank don't tend to expose their faces and appearance and everything to potential witnesses for 10 minutes the day before they commit a robbery, right? Everybody see how that could be relevant to at least those two facts? And then if you knew what the conversation was, maybe, you know, you get some more relevance about, you know, what the schedule is and when they change shifts, and does he or she, that teller work, you know, what hours and things like that, right?
Questions about number one? You see, it's your job. If you want this evidence in, it's your job to come up with the reason why it should come in.
I have a question. So, on the second, on the fact that you could use, or these facts using to disprove that a person wouldn't show their face, that's more of a defense argument.
Right.
As the prosecution say, if the first reasoning failed for showing why it's, how you could prove with these facts instead of disprove, would you want to then, if that failed, you would then want to say that this is relevant because it could disprove the fact that he wouldn't show his face, even though that's more of a defense argument, but you're just trying
You
to
can
get-
say that to the prosecutor, the judge is going to laugh, well, why do you want to get it in?
You want to argue for bases that help your case, not that hurts your case.
Well, no, I understand, but
Right.
I'm saying just if your first argument fails in order to get the piece of evidence in, say.
Yes, you could always say, and what's more, Your Honor, it shows that, you know, maybe this isn't the guy because he was there, but either way, it tends to prove or disprove something of consequence. You could try that. I wouldn't recommend it.
I was just curious as if your first argument fails.
Yeah, no, absolutely. You
To
could,
get it in, and
you
then
could argue
later-
that it's relevant in a way that hurts your case. You could do that. Probably not your best argument.
But then later, when it comes into trial, could you then revert back on your first argument?
Well, of course, when you argue the case to the jury, you explain why it helps your case, sure.
Okay.
But at this point, we're just trying to get it in, not explain why it matters to the jury.
Right. So when you're explaining to the judge, this is relevant because it shows that he was going to the bank. He's been at the bank. He's familiar with their operations. He knows how many tellers work. He knows how many customers are there. He knows how many securities are working there. Whatever. Yeah, counsel, that's not relevant. Well, it also shows, right? And then you would go into other reasons as well. You don't just give up, right? Because remember, your hurdle is this much,
Yeah.
right? And any one of those would make this more than relevant.
Yeah.
Any one of those. But if the court says no to your first one, you go to the next one, and then you go to the next one, and you go to the next one, until you find one.
Eddie had an 8-year-old bank robbery conviction in a different state, Maryland. Yeah, I care what different state it is.
Relevant?
Anybody? Well, sure. Why is it relevant?
because it would make him more susceptible, you can maybe draw an inference that it could make him more susceptible to robbing a bank.
Guys that rob banks once, more likely to rob them again. Also shows he knows how to do it. Right?
Right.
Also goes, if Eddie's gonna testify, goes to his credibility. Right? It's a crime of moral turpitude. So it goes to whether you can believe him or not when he talks about, hey, I wasn't there and it wasn't me.
Eddie,
Now, understand, this doesn't mean you get it in, it just means it's relevant.
so don't confuse it. Relevancy.
Admissibility is different than, now, if it's not relevant, you're not getting it in, right? It's not gonna be admissible if it's not relevant. You don't have to worry about 403 or anything else. But there may be more hurdles besides the, is it relevant or not?
Right? And all of those hurdles were laid out for you in some form or fashion in 402, right? Where relevant evidence wouldn't be admissible for any one of these other reasons. But for right now, assume
You're just talking about one hurdle.
you're trying to get this in, and your opposing counsel's objecting relevance. And what's your response? Right? And he's fired from his previous job as a clerk in a convenience store, and as a result of an unproven allegation that he stole money from the cash register. Is that relevant?
I would say it's not relevant because the allegation is unproven.
How about if how about if ignore the reason he got fired from his job? Do people who need money rob banks? Do people who get fired from their jobs need money?
No.
Okay.
Right.
It's not
No.
it's not any more complicated than that, right?
Yeah, don't jump into the catch of saying, here's why it's not relevant. Your job is to find out why is it relevant, right? And here, that's a great motive. It's unemployed, right? That's why he's robbing banks. You know who doesn't rob banks? Guys who got a lot of money because they're working all day.
I suspect the percentage of unemployed bank robbers is pretty damn high.
Number 4, Eddie's participated in 2 ballroom brawls the week before the bank robbery.
Relevant? Why? You're nodding yes. Why?
Because it goes to prove that he has violent tendencies.
And robbery is a crime of
Robbery is
violence.
violent crime.
Somebody who gets in a ballroom brawl is more likely to engage in violence in other ways. Okay.
Eddie was divorced and delinquent on his payments of $400 per month in child support.
Showed he needed money.
Yep.
So he needed money. Goes to motive, right? Simple as that. Eddie was broke. His only asset was a $49 savings account at a different bank. Right. Same reason. All those kind of go right back to this idea that it's relevant because it goes to show a motive for robbing the bank. And he owned a rifle.
Yes, because you could infer that because he owns one gun, he could possibly own other guns, which was used in the robbery.
Pretty common, don't you think? Most people either own guns or they own no gun, right? Most people that do own a gun own more than one, and most people, or they don't own it.
Again, it doesn't mean that it's real powerful evidence, just that it has a tendency to make something a little bit more likely or unlikely. Something that matters.
He's got 2 kids, ages 2 and 7.
He needs money to provide.
Sure. Yeah. Those kids eat a lot, right? They need school supplies. They want to sign up for soccer, and all kinds of stuff that costs money. And he's been convicted of marijuana possession on 2 separate occasions in the past 4 years.
It's clearly not California. Anybody think that's relevant? How come? Those druggies tend to rob banks.
Committed crime before.
Yeah. Boy, is that the slimmest of relevancy. Yeah, that's the only way that I can think that's possibly wrong. You're gonna break the rules, you're gonna break the rules. Break little rules, you'll break big rules.
Criminals commit crimes, right? Drug addicts steal, right? Drug users steal. However you want to get to it,
Yeah.
right?
By the way, good luck with that.
Smoking marijuana gets you hungry.
Yeah.
And you get hungry,
Then
now
you
you
run
need
into
money
my
to buy
emotions.
your snacks.
Like I say, good luck with that.
You start with devil's lettuce.
Eddie prefers rock to Bach and gin without tonic.
Okay, this is gonna be good. Anybody got that one as relevant?
I'll say that,
And how do you get there?
because he likes to live on the edge. Likes to live-
Yeah.
Gin's pretty strong.
Right? You know how those rockers are,
I know.
Jeez.
right?
Yes.
They grow their hair and they wear those spikes and black and,
Put down their country, yeah.
you know.
Yeah, all right.
And he likes his gin without tonic.
So therefore, he must be British and follows the rules. Whatever. Yeah. I'm not sure about Tim. But you see the idea, right? You want to get it in, find a way that it matters that it makes something more or less likely, something that matters more or less likely. And it doesn't have to make it a lot, and it doesn't have to matter a lot for it to be relevant.
Okay, so here's, just real quick, I'd like you to just kind of see, it's easy to identify or to come up with a reason why something's relevant. If you can't come up for a reason, now whether it's a winning one or not is a different story. But you should have no problem coming up with how something is relevant to a case. You should be able to find some inference chain that would make something relevant. Okay, now whether it's a winning argument or not is a different story, but you should be able to do that. Okay, well, what I'd like you to take a look just real quick, because we were studying objections, right? So take relevance out of the equation, right? If you were the defendant and they tried to offer these 10 items of evidence, right? Can you see objections to them?
I'm gonna object to everything.
Right. Well, yeah, you can find reasons to object to all of them, right? But some of the basic grounds for objections, right, are you're dealing with something that happened at a different time. You're dealing with something that happened at a different location. It's a different object. It's different people involved. There's different legal issues, different elements, right? If they're dealing with something that's not pertinent to your case, those are all grounds for objecting, right? If you look at like 1, 2, 3, and 4, all of those have to do with a different time, right? None of those had to do with the date of the robbery, right? And 2, 3, and 4 had to do with different locations, right? Convictions in a different state, right? And a convenience store, and a bar, not at the bank, right? 8 has to do with different people, it's dealing with his kids. 7's dealing with a rifle, not a Saturday night special. That's a different object. Right? 5, 6, and 10, right? Child support, right? Being broke. The type of music you prefer. None of that goes to the elements that are necessary for a robbery. So, finding those sorts of differences can help you identify whether something is objectionable or not.
But then that starts getting onto, it's relevant, but how relevant, which sort of leads into 4.
Right? So what you're going to see as we develop our foundation here, okay, ultimately you're going to be given a fact scenario and you're going to be asked, kind of like we did right here, maybe just as obvious, maybe not. Are these items of evidence admissible? And you're gonna have to be able to articulate, are they relevant? You're gonna have to be able to articulate, are there objections to them? Right? We're gonna get to 403. You're gonna have to articulate the balancing that you're gonna do. And you're gonna have to articulate, are there any specific rules that deals with this type of evidence? A number of these, you'll learn there are specific rules that deal with them. We haven't got there yet, we're just dealing with relevance, but you'll find out a number of these probably aren't admissible because there's a rule that says they're not admissible. Doesn't mean they're not relevant, just means they're not admissible. So, but what I want you guys to understand right now is, do you still have, don't lose what we've been working on, looking at this stuff and seeing, is it objectionable? Okay? And now we're adding to the equation, is it relevant? Okay? Telling you right now, we don't expect you to be saying, or if you do, it's going to be a rare occasion, yeah, this piece isn't relevant. And we expect you to say, here's my rule for relevancy, and here's how it's relevant. Because you should be able to come up with a reason why it's relevant. Doesn't mean admissible, means it's has a tendency to make a fact of consequence more or less probable. Okay? Let's do one more of these. Okay, let's take a look at 3-6. Who wants to jump in there?
And
There you go.
Do I need to stand? I don't understand. Scotty was a driver for the Lautrec company. While driving a Lautrec truck, Scotty collided with a car driven by Kurt. Kurt sued the Lautrec company for damages and tort based on a theory of respondeat superior. So the parties reached a written stipulation on most of the facts. The only issue at trial was whether Scotty was acting within the scope of his employment at the time of the accident or whether he was on a fun and frolic detour. Plaintiff Kurt offers evidence that at the time of the accident, Scotty was not looking where he was going. In fact, he was falling asleep. Is this evidence relevant? If so, relevant to what?
This is a trick question.
Well, they said the Lautrec companies and damages on the theory of respondeat superior.
Mm-hmm.
And the question is that relevant to their what they're asking for, what their argument is. It's relevant in who, if he was negligent, but it doesn't really speak on the respondeat superior portion.
You guys see that? Good job. Right? Does the fact that somebody is falling asleep and not paying attention, is that relevant to an accident case? Most people say, yes, of course it is. Well, it's relevant to the negligence claim, right? But the question tells you that's not an issue here. They've stipulated to all of that. The only issue is, was he working within the scope of his employment, or was he on a fun and frolic detour? Right, that's the only issue. Now, knowing that, could you make this relevant?
Get more facts, maybe.
Right. He was not looking where he was going. Right. In fact, he was falling asleep. Well, most people don't fall asleep when they're at work. Right. But maybe if they're having fun and frolicking around on a detour, right, they're not going to be paying attention, and maybe they're falling asleep. Right. Remember, we're not necessarily looking for a winning argument, but can you find something there that there is to argue? Okay. What this question does is it hits that second part, right? It's got to be a fact of consequence. That clearly falling asleep at the wheel, that's relevant to a car crash. not if that's been stipulated away. The only fact left is, was it within the scope or not? So if you're gonna argue for its relevancy, you've got to tie it to that particular issue. Let's look at 3.7. We got one for all of them.
Hal was driving in his car when he turned on the radio and heard that his own house had burst into flames. Hal was subsequently charged with burning down the house to obtain the insurance proceeds. At trial, the prosecutor intended to offer evidence that Hal took out additional fire insurance 7 months before the fire. The following exchange occurred at trial. Prosecutor, Wanda, as the insurance agent for the defendant, Hal, could you please describe the insurance that Hal had on the house, especially within the past year of its construction? Objection, Your Honor, irrelevant. Counsel, please approach the bench. How would you argue this objection if you were the prosecutor? How would you argue the objection if you were the defense counsel? What ruling would you make if you were the judge?
Could be the prosecutor.
Sorry, sometimes when I read things out loud, I don't retain it at all. I have to reread it. So the prosecution would argue that the extent of the fire protection that he, in his policy, could draw inferences to, he just took this out 7 months prior and he got extra fire protection in anticipation of this house burning down because
So simplified. People who burn down houses for money increase the insurance before they burn them down. Right?
right.
That's what you're saying.
And if you just step back, well, right? Don't get caught up in all the words. What is the prosecution trying to offer? That this guy bought additional fire insurance before his house burned down.
So he'd get more money when he burned down.
Right. That's a
That's it.
classic criminal motive.
Money.
Right? Money. Right? If you watch any of those shows on crime and what? Right? Yeah, that's always Dayline. That's always the motive. They always look at the spouses and the boyfriends, and what do? They always got brand new life insurance policy, and then their spouse disappears. Right?
It's a mystery.
So whenever you see something like that, classic motive. Okay? Now, if you're a defense, why are you going to say what's your argument for why it's irrelevant?
That he was up for renewal in his policy, so he just happened to.
Does it tell you that? Don't create stuff that's not there. Right? Now, what did I just tell you about objections? Look for the differences, different time, different place, different people, different locations. Is this relevant? He did this 7 months ago. Not like he bought this insurance yesterday and then burnt down his house. Bought additional insurance 7 months ago. How is that relevant to the fire burning down today? It's not relevant.
Yeah, you're right. The prosecution will get the better.
Right, and then the judge has to decide, right? Is it relevant or is it not relevant? But you see, that's what you want to start looking at, okay? And I'm going to caution you now. It's going to be nagging at you to add facts. Don't do it. Don't add facts that aren't there. Okay, deal with the facts that you're given. If you need additional facts, say what those facts are. Like, I would need additional facts regarding this to make a decision on this. Tell us that. But don't start putting facts in there that aren't there. Okay? Take what they give you and analyze what they give you. Okay? 3-8.
John and Joanna are being prosecuted for robbing a bank on June 4th at 9 a.m. The defense was mistaken identity. At trial, Tommy, the bank teller who was robbed, testified about the robbery. Tommy, directing your attention to 8:55 on June 4th, where were you? Objection. Where the teller was at that particular time is irrelevant. Is the question necessarily irrelevant? What answer would make the question relevant? Well, it would be relevant if they put him at the scene.
Yeah, if he's at the bank, more particularly if he's somewhere where he can see the robbers, right? Because it's only 5 minutes before the robbery.
What answer would make the question relevant? Well,
Right, okay. So, next question.
how did you feel Tommy, as the robber, handed you the note that read, "Your money or your life"? I felt. Objection, irrelevant. How the teller felt is irrelevant to whether a robbery occurred. So,
To the prosecutor, what do you say?
well, first of all, as a robbery, there has to be force or fear.
Right.
So if he felt fear, and then I would also argue as a prosecutor that
Yeah, but does it really matter that he actually was afraid? He got a note that said your money or your life.
or your life.
Right.
When you're scared, you tend to recognize the face that's.
You tend to remember what the hell is going on right at the moment, huh? It like stands out in your memory. It's like seared in your memory because, and actually I can tell you from having tried a bank robbery case like 12 years ago, this is two years after the bank robbery when the prosecutor just lifted the gun, holding it by the handle and with it pointing down at the counsel table out of the evidence bag that it was in, she burst into tears. I mean, it was that traumatic. She, it brought it all back to what she was feeling when that gun was pointed at her. And at least one of the tellers was like, I was thinking, I kissed my children goodbye for the last time this morning. So, yeah, it's relevant because it might explain why she really, really, really remembers what happened in that instant.
Okay. Now let me just stop right here. This just like a little tip for all of you for test taking purposes, right? On this particular question, there's a bunch of reasons why it's relevant, right? Give us your best one, right? You don't need to write 20 reasons why it's relevant, right? And your first one, this goes to an element of the crime, force or fear, done. Move on, right? This is relevant for this reason, go on. Don't say, oh, but if you don't think it's relevant for that, here's this other reason why it's relevant.
Yeah.
If you didn't think about the force or fear element and you thought, hey, well, it's going to show why they have such a good memory about this because it's such a traumatic event, okay, write that down, move on. Okay, don't necessarily write multiple reasons why it's relevant. You'll never finish the question. And if you're just trying to analyze why every little possible relevancy that could be there. Okay, so you're the judge, you let it in?
Yeah, of course.
Overruled.
Of course.
Okay. Who wants to do Benny and the Jets?
Any Elton John fans here? Yeah.
I'll do it.
Okay.
Anybody ever heard of Elton John?
I've heard of Elton.
The defendant, Benny, is charged with distribution of cocaine. The prosecution calls Benny's friend, Jets, to the witness stand to testify that he, Jets, had used cocaine with the defendant 3 months prior to the defendant's arrest. Prosecutor, Jets, please tell the ladies and gentlemen of the jury where you were on March 6th at approximately 3 p.m. Answer, I was at the Giants football game with my friend Benny. Prosecutor, describe what happened between you and Benny at the game. Defense counsel, objection, irrelevant. Is this evidence relevant to the charge of distribution? Explain.
Think about it. What does it take to distribute cocaine? know what cocaine is, right?
Right.
If you use cocaine before, does that have a tendency to prove that you know what cocaine is?
Yes.
Voila! That's at least one ground for it being relevant. Right? Everybody see that's not overwhelming evidence, but it's helpful. And it might help the prosecution say, well, Benny didn't make a mistake about what that powder was. He knew. And how do we know? Because he used coke before.
Right? It's a real common argument in drug cases, right? Is that you don't know what it is. And as a prosecutor, you love that because
Right.
you say you don't know what it is. Your Honor, I want to enter all their prior convictions that show they knew what it was because they've been convicted of possession or use or under the influence before. No, we know what it was.
Yeah,
we don't want to argue that anymore. Right? Well, probably the most common ones is those aren't my pants.
Yeah. It's amazing how many dudes have other guys.
I didn't know that was it. Those aren't my pants.
There's an epidemic of guys wearing other guys' pants. And nobody ever gets a hold of pants that don't have meth in them.
All right. Who wants to do 310?
Okay, so everybody say, it doesn't have to be like a big fact, a little fact, and a logical connection. So. Which one are we doing?
310.
310?
So,
Arnold.
the defendant, Franz, is prosecuted for assault and battery on
Arnold.
Arnold.
It's like how you say Arnold without
Arnold.
with a
Schwarzenegger.
Schwarzenegger. Arnold.
Franz claims self-defense. Franz testified that immediately before the altercation with Arnold, Franz was told by a third party that Arnold, a weightlifter, was out to get him.
Okay.
Is this testimony relevant? And relevant to what? I would say it is relevant.
And why?
But why? Because it's stating that somebody else was, he was in fear.
That he was told that this guy, a weightlifter, is out to get him, so he's going to keep himself from getting gotten. Right? So it's relevant to his belief, his reasonable belief, that he had to use force to defend himself. And whether that belief was reasonable. Okay.
Does it matter whether Arnold was in fact out to get Franz? Yes,
Why?
because it'll prove that Franz was protecting himself.
Okay, so if Arnold really was out to get him, then it's more likely that his belief that he was out to get him was reasonable.
Right.
But even if Arnold was, you see, it is relevant, but it can still be self-defense otherwise, right? So it's a fact of consequence, whether he reasonably believed. And the fact that this reasonable belief happened to be true tends to make that fact more probable.
Okay. Okay.
Everybody follow that? You don't have to prove that that reasonable belief was true, but it helps.
Okay.
Because if it really was true, it makes it a hell of a lot more likely it was reasonable. Okay.
So if Franz cannot recall who told him that Arnold was out to get him, is the evidence still relevant? Yes.
Well, yeah, because it still goes to whether he reasonably believed that somebody that Arnold was out to get him.
Yes, it's not relevant because of who said it. It's relevant because it goes to his belief, right? Now, it might be stronger if it's
True.
somebody he knows,
Oh, I see.
right?
Somebody who knows,
And of
knows
course, if
Arnold.
it's true, right? Franz has been flirting with Arnold's girlfriend, right? And Arnold's girlfriend comes up to Franz. Arnold's on his way over here. You've got to get
You better get going.
yeah, right. Maybe it's more believable because the girlfriend just told him. But not knowing who it came from doesn't make it less relevant. Right? Just might not make it as powerful evidence.
Because remember, It just has to be relevant. It doesn't have to be like really, really, really relevant. We'll get to really, really, really relevant later.
And I'm gonna give you the bottle of red in 3-14.
Oh, you were giving it to us.
No, I know. Giddy up. You're ready. You're ready.
Billy was observed purchasing a bottle of red wine at a liquor store at 2 p.m. On Tuesday, at 7 p.m. on the same day, he was arrested for driving while intoxicated on the local highway. The prosecution offers evidence about Billy's wine purchase and Billy's subsequent trial for driving while intoxicated. The defense objects. Should the judge admit the evidence? Sorry, let me read this one more time.
The evidence is he purchased a bottle of red wine at 2 p.m., 5 hours before he was arrested for DUI. Relevant?
It's relevant because it may have been used for.
Yeah, people who possess alcohol make it more like, somebody who possesses alcohol makes it more likely that they consumed alcohol, right? And this is only 5 hours before the incident. So yeah, it's not relevant, right? Everybody get that? Okay. Wait a minute. What if somebody saw Billy not purchasing a full bottle at 2 p.m., but having an empty bottle at 2 p.m.? Still relevant? Why?
Should have drank it.
Yeah, it might suggest that he drank it, and maybe he's still a little drunk by 7 p.m. May not be super powerful. You might have a response to it, like, hey, you burn off a glass of wine an hour. There's only 5 glasses in a bottle of wine, so even if you drank the whole thing by 2 p.m., you'd be sober by 7, probably. But it's still relevant, right? Just because you can rebut it doesn't make it not relevant. Okay? Half empty. Ooh. What about that? Is that relevant? People who possess alcohol are more likely, or makes it easier for them to drink it. Yeah.
But you see that the argument is the same regardless.
Yeah.
Right? For relevancy purposes, if you're possessing alcohol, it makes it more or less probable that you were under the influence of alcohol, right? Which is what he was charged with.
Ooh, what about number 4? Anybody?
He was keeping the party going.
Yeah.
There you go. He started out fancy. Right? I got this nice bottle of red wine. It's like,
Drinking wine.
no, it's too expensive.
I'm drinking the beer.
No, I gotta finish drinking beer.
Yeah. People who drink.
So, I hope you guys you see that when we're talking about relevancy, there's different. Some pieces of evidence are more relevant than others. Okay, but for purposes of arguing that something is relevant, that's not required. Okay, you've just got to demonstrate that it makes something more or less probable. Period. Okay, and if it does, right? What if he was seen carrying a full bottle of wine at 8 o'clock in the morning? He's arrested at 7 p.m. Right? Is it relevant? Sure, for the same basic idea, right? People who have and possess alcohol are more likely to be intoxicated than those who don't. Right? Let it be argued later how relevant it is, how important it is. Right? If he's arrested at 7 and he's got a 95% empty bottle of wine, and he smells of wine, it's much more relevant than whether he's intoxicated at that point. but that doesn't make it irrelevant that you have to follow at 8. Okay? So your job with regards to relevancy should be real simple. Here's my rule. Here's my reason that makes it relevant. Let's move on to the next step of the analysis. Okay? And what we're going to discuss with you, and we get into 403 next week, but what we're going to discuss with you is a format for which that you're going to answer your questions. Okay? You're going to start with 401, you're going to end with 403, and in the middle you're going to analyze based on all of the rules that we've given you that may be specific to that type of evidence. Okay? So it probably is a good time to point out to you that some outlines do it. I don't know if Fleming's does or not. What we're talking about right now under 401 is called logical relevance. Okay? For some reason, on bar exams and on law school outlines, they use this distinction between logical relevance and legal relevance. Okay? So I want to make sure that you understand it. All we're talking about now is logical relevance. Can you use your logic? Can you think of some reason why a piece of evidence would be important and make it a factor of consequence more or less probable?
Yeah.
Right? That's what you're using your brain. Can you logically articulate a reason why? Does it matter if it's admissible or inadmissible for other purposes? Right? You may know that something is not admissible. That doesn't mean that's not a basis for making something relevant. Okay? So when you're analyzing whether something is relevant, don't say, yeah, well, this would make this fact of consequence more probable, but since it's not admissible, it's not relevant.
It's still relevant.
Right? It's still relevant. Okay? Legal relevance, which we'll talk about next week, is when we get into talking about legally, is there some reason why, even though it's relevant, it shouldn't come in. Okay? 403 deals with admissibility, a legal argument that we're going to deal with. So why don't we go through our outline real quick. So this is the most basic rule of evidence. Right? It's got to be relevant to the case. Irrelevant evidence is excluded. Right? If we're trying a bank robbery case, this should talk about the robbery and not about whether banks are in a conspiracy to make obscene profits on high-risk mortgages and things like that.
Yeah, so just because the banks are robbing us doesn't mean that we can rob them.
Okay. We've already gone through 401 and 402. To be relevant, evidence must have some tendency to prove or disprove one of the issues or disputes that are of consequence in the determination of the case. Right? The key phrase is any tendency. Right? To help.
Even, no matter how slight.
It's a very low threshold.
So you might think of it as just having some slight tendency to push the needle, probable or less probable. Just a little.
And so, by setting the standard so low, basically what the legislature has told us is we favor finding evidence relevant. Okay? There's a strong policy, and you'll see it repeated in the rules as we go through them. There's this strong policy that favors the admissibility of relevant evidence. And that's always an argument you can make. it's not necessarily a winning argument, right? When you stand in front of the court, you say, well, Your Honor, there's a strong policy that favors the admissibility of evidence, so I want you to admit this evidence. You know, you're going to have to do more than this, policy favoring to convince a court or something, right? It's there, and it looks good. You put it in your briefs, and you maybe you mention it in your oral arguments, but you better have another argument.
You certainly mentioned it, the other side is saying, this is irrelevant, Your Honor. Really? Well, there's a strong policy to favor, the admissibility of evidence, even if it's only marginally relevant. And this is at least marginally relevant.
So when we're talking about whether an item, right, has any tendency to help prove or disprove something, that's a matter of logic. That's a matter of common sense. Right? Does it make you, when you hear this, does it make you think, yeah, one way or the other? Right? We had a good laugh about it. Like, okay, when you heard that this bank robber liked rock and instead of classical music, did that move you one way or the other? I know when I hear rock, I picture a certain type of individual. Yeah, I do. Yeah, and I'm sure you do too. Your person might not look like my person, but I know I picture somebody when I hear that somebody likes rock. I picture somebody when I hear somebody likes Bach, right? And that person comes with certain traits and stereotypes. And I can tell you in my gut, rock people are probably more likely to commit bank robberies than Bach people. Is there any logic to that? Is there any science to that? Probably not. But it allows you to make that argument if you got nothing else. Right? If you got no other reason why this is relevant, why are you trying to offer it? If you are trying to offer it, what's your reason for wanting to offer it? Okay? People who drink their gin straight, well, they gotta be hard drinkers, right? Everybody cuts their gin to a tonic. And if you're a hard drinker, well, who are you? You're probably somebody that hangs out at bars, right? You're probably somebody that gets in bar fights, and rob banks, right? Does that inference chain convince a jury? Probably not. Okay, but for purposes of overcoming the relevance bar, it probably does. Okay, very barely, right? It's tripping over that bar. But, just use your common sense and, the reality is if you can't think of why something is helping your case, how it's making a fact of consequence more or less probable, why are you trying to offer it? If you can't even come up with a reason why. So you probably shouldn't. Okay. Now, whether an issue or dispute is of consequence, right? That's a matter of law, right? That's related to the elements. That's related to the cause of action. That's related to affirmative defenses. What's been admitted in the pleadings, right? When we talked about respondent superior, right? Negligence was a non-issue. It's been stipulated away. Okay, so for that case, that wasn't relevant. But let's say they hadn't stipulated to that, right? And the issue was, did he cause the accident? Very relevant that he was falling asleep and not paying attention. Okay, this is often called materiality. You'll hear those words interchanged. People say it's immaterial. What they're saying is it's irrelevant. Somebody says that it is material, they're basically saying that it's relevant to the action. Okay, for example, in an auto accident case, if the plaintiff was driving over the speed limit, is of consequence only if contributory negligence has been pleaded as a defense. And only if the plaintiff has declined to admit it. If they've admitted it, it's a non-issue. Right? You don't get to just keep going over that. So evidence rarely has zero relevance. And if it did, you shouldn't be presenting it. Okay, the problem usually is one of pretextual relevance, right? You're offering something that has little genuine relevance, but you've got some ulterior reason for doing it, right? They're charged with possession of child pornography. The prosecutor may offer evidence from a witness who claims the defendant is a former priest who molested him in '92. There's arguably some relevance, right, to this accusation, even though it's remote. What the prosecutor really wants to do is convince the jury that the defendant is a dangerous pedophile who needs to be locked up. Really, that has nothing to do with possessing child pornography, okay? And there's nothing wrong with admitting relevant evidence, even though that's not the reason you want it, okay? Let's make sure we're clear here. We're not talking about arguing at some point, right? If the prosecutor argued, stood up and said, this person should be locked up because they're a child molester, inappropriate argument, right? Because it's not being charged with child molestation, okay? But if somebody's been convicted of child molestation, that seems relevant to whether they might possess child pornography. Yeah, probably does. And if you can get that in, oh, that's going to go a long way towards convicting this guy, right? If they hear that he's been a child molester. They probably will never hear that. And you'll learn why next week. But if you could, wow, that goes a long way, right? So don't be, just because the relevance that you have isn't necessarily what you want to argue it for, doesn't mean you don't bring it in, right? Sometimes you bring it in and you'll let the jury connect the dots and you'll never even talk about it, right? You bring the evidence in and they're going to connect their own dots on their own. Yeah, that guy was a bank robbery, he likes to rob, right? Whether you even ever have to tell them that, okay? And that's where Rule 403 comes in, right? That establishing a balancing test, which will weigh whether something is genuinely probative versus whether it's irrelevant and has a prejudicial effect. No need to go into that more now. We're going to hit that hard next week, right? There's one other important concept that's known as conditional relevance. We talked about in the context of 104, right? Right, sometimes the case that the relevancy of an item depends on whether you can prove a connecting fact. Right? We talked to the O.J. Simpson. We talked about his shoes and the picture of the shoes and then the bloody footprints and so on and so forth, right? If you're able to connect the relevant dots, then it becomes relevant, right? So maybe your initial argument is, Your Honor, this might not be relevant on its face, but it's conditionally relevant because when I offer this piece and this piece, oh, now they present a different picture, or they present a more fuller picture that you can demonstrate is relevant to a fact of consequence. Okay? And one of the things that you need to just kind of keep in mind is, right, whether something is relevant depends on not just the type of case you have, the elements that you have to prove, what's been stipulated to, what's been admitted, so on and so forth. but sometimes it goes to other issues like a motive that necessarily isn't something that you have to prove, but if you can prove, you
That
like
sure
to,
helps.
right? You know, there's an instruction that says you don't have to prove motive, but if you can prove motive, it goes a long way.
Yeah, if the defendant had a motive, it may tend to suggest that he committed the crime.
Okay, that being said, let's take a look at a couple more of these and make sure you have a good understanding of them. And then we will call it a night. Okay? Let's do, who wants to do 311? Arnold's younger brother.
Slide.
Slide.
Somebody like an old movie references here. Who's reading 311? All right, okay.
So Arnold's younger brother Slide was stopped by the police late one Saturday night while driving on the interstate. He was glassy-eyed and appeared to be intoxicated. When he refused to cooperate with the detaining officer, the officer called for backup. Before the backup arrived, an officer mistakenly thought that Slide was reaching for a gun and shot him dead. In a civil rights action brought by the survivors of Slide, the officer testified as follows. Officer 2J. I saw Mr. Slide move his hand toward the pocket of his jacket like he was reaching for a gun. I thought he was going to shoot at me, so I took the safety off of my weapon and shot him. The plaintiff wishes to offer an evidence that in a search of the victim after the shooting, no weapon was found. Is this evidence admissible? Explain. I would say it goes toward the reasonable belief that for all intents and purposes, he thought he did have a gun. He was reaching for his,
Yeah, was this belief reasonable?
it was reasonable.
So if there's no gun, well, might tend to indicate that the belief wasn't reasonable, or that the officer just flat out lied that he thought he saw a gun.
And the counter to that?
Would be, just because someone moves, just because someone's reaching his pocket doesn't mean it's for a gun.
No, that would be the plaintiff's argument, right? The flip side of that would be, it doesn't matter if he has a gun, right?
Right.
As soon as his hand went into his pocket, officer's life was in danger, he reacted. So the fact that whether he had a gun or not is irrelevant, because I didn't act, Officer 2J. Officer 2J didn't act because I saw a gun. I acted because I thought he was going to pull a gun. No, that's irrelevant if he had a gun or not.
Yeah, good luck with that.
Right? But that's the flip side of it. Right?
And here's what the other side's going to say, which sort of responds to the argument, but not really. Well, you can bet if they had found a gun, we'd be hearing about it. Right?
And that's irrelevant.
And good luck trying to explain why the presence of a gun would be relevant, but the absence of a gun is not relevant. There are some very well-paid defense lawyers who get to argue that, and some of those guys are really good. But,
312?
and shouldn't the officer have planted a gun on the guy? I mean, really?
You would think, don't think they all carry a spare.
Yeah. That's what they said in that movie I saw. Okay, what's next?
We got two more.
Sexual battery. Who wants to do sexual battery? Yeah, all right.
Yes.
There you go.
Joe is charged with sexual battery. To prove the victim's age, which is relevant to the elements of the offense, the government offers evidence that Joe generally dates women between the ages of 15 and 18. If you were the judge, would you find that this evidence is relevant to this case? Why? Yes, it's relevant because it'll show that Joe has a tendency to interact and date with young girls.
Fact of consequence, age. Fact that Joe goes out with people in that age range, Yeah, there's a tendency and reason to suggest that he's going out with that he knew that she was that age, because that's what he liked. Okay, what's the flip side? Who's gonna argue it's not relevant? Anybody?
Well, I'm guessing if you're the defense attorney, you would say he dates them. It's not necessarily this is for.
Just because he dates other women who are 15 to 18 doesn't mean that he was dating this one or that this one was 15 to 18, right? Other women, other time. Well, women, other girls, other time, right? Not this time.
Generally, right? It doesn't say always.
And he could have been wrong, right? Maybe
He
this.
doesn't know.
Yeah.
Well, is he asking them how old they
Yeah,
are?
spoken like a prosecutor. No, wait a minute. The prosecutor would be like, of course he knew.
Yeah. How does Joe even know? All right. 313 is we get to have some fun with.
We're having fun with the sexual
Okay.
character.
So, this is based on a true case.
Oh yeah, this is a famous or infamous case in New York on the subway.
Sean was approached by 4 youths
Utes.
while riding on a nearly empty commuter train one weekend morning. The youths stood on both sides of Sean, 2 to a side. One of them said, "Give me $5." Sean, fearing an attack that would result in serious bodily harm, took out a revolver, shot the 4 youths, injuring each of them seriously. In a subsequent prosecution for attempted murder, which of the following facts is relevant? Sean or any of the 4 youths is male or female? Not relevant?
Yes, because it can show how intimidated he was,
Or she was,
or she was.
right? Sean's a girl, right? 4 guys surrounding her and demand money. Relevant to show she was reasonably feared that she was going to get attacked? Who's going to say not, right? Flip it. 4 girls. Yeah, maybe it's not quite so reasonable, although, man, there's some tough girls on the subway. Or people who identify as female.
Or Sean or any of the 4 youth is of color or Caucasian?
Could be a hate crime.
Or not, he's not charged with a hate crime. Did the question say anything about a hate crime? Nope.
Well, I'm trying to think of a nicer way to say it, but yeah.
Well, don't think of a nicer way to say it, because that's not part of the question.
Is it relevant?
Attempted murder. Sean's a black guy surrounded by 4 white guys. Might 4 white guys be more likely to be going after a black guy or vice versa? Anybody gonna say that a reasonable juror couldn't infer that maybe the 4 guys of a different race were going after the victim? Or alleged victim, the person that fired the shots? You bet that would play into it,
You will
right?
see, regardless of the caution you would want to use in addressing the jury. A trial is not a place for political correctness. Okay, you need to call it what it is. Okay, where the fact that they're different races matter, yeah, it does. It does. And it does, right?
But you
Sean's Asian, and the 4 guys are Hispanic. Does that matter? Yeah. I didn't understand what they were saying. I don't speak English. They said, "Give me $5." I got scared. I know what they do. Those guys, the ones that wear jackets and beanies, and hoodies, and their
So
pants.
It's just asking, like, could it matter? Could
Correct.
it potentially
Right.
matter? That's
Right.
all it is.
Which
If you draw an hate
is
crime,
relevant.
yeah, that would make it more or less likely that it was attempted murder. Sure.
Right, at this point, you don't have any other facts that he had 2 people come up to him on either side, and they said, "Give me $5," pulls out a revolver and shoot. That's all you know. Does their race matter? It does. Okay, it's relevant. okay? And don't shy away from saying that, okay? Sean or any of the four youths is younger or older than 21.
Sean's 17, they're all 23. Anybody think that doesn't matter? As to whether Sean was trying to kill him or was reasonably afraid that he was gonna get attacked? You bet. And reverse it, maybe it's less, right?
Sean is of high, average, or low socioeconomic status.
I would argue that based on their socioeconomic status, if they were in need of money or not.
If they're poor, hey, they're more likely to be robbing them, right? Ooh, he looks like he's got money. They're more likely to be robbing him.
What if they're gay, lesbian, or straight? Doesn't matter. Right? Here's where this gets a little bit tricky. Okay, everything else that we've kind of talked about, you can identify physically, right? Whether somebody's male or female, you can be wrong, right? But you can say you look like a guy, you look like a girl, you look black, you look white, you look old, you look young, right? You look poor, you look rich, you're wearing a suit, you're wearing, garbage bags for shoes, right? There's types of things that you can identify. Just on the fact right here, do we know, how would you know if somebody was gay, lesbian, or straight?
Just with a dress code and talk.
Maybe, right? So that's what you gotta start thinking about is, you haven't got any more facts, right? But is it relevant that they're gay, lesbian, or straight? Sure. To the extent we know that they are or aren't, right?
How about if the guy that did the shooting or the person that did the shooting is transgender? Yeah, I think that's gonna matter, huh? Because they might be picking on him just because of that.
What if any of the four youths had a prior criminal record? Relevant?
We don't know what it's for. Maybe it's that weed smoking. Maybe it's assault. Maybe it's illegal possession of a firearm. Boy, we'd like to learn more about that, huh?
You should be able to articulate how that would be relevant to make the fact of consequence of whether they left him in fear.
He doesn't know they have a
More or less
record,
probable.
right? He doesn't know they have a record. He doesn't know anything about them. He just runs into them on the subway. So does it really matter whether they have a record? Anybody? Well, sure. If they had a record for violent crime, right, that would tend to indicate that they were more likely that they were committing a violent crime this time. We're not talking about admissibility again, just relevance.
Does it matter if the train's is a subway or it's above ground?
Yeah, if it's in a subway underground, it'd be more likely to happen in a secluded area than above ground in public.
Well, you're on the train, right? You're in the same train car, whether it's above ground or not. But maybe more people can see it from outside if it's above ground. Maybe.
So just you want to start thinking about these things, and yeah, I think you can make an argument that if you're in a subway, right, you're more likely to. It's an empty train to come at me and try to mug me if there's no witnesses, right? Passerbys, cars that you might see if the train's above ground. But if it's located in a rural area, the suburbs, or an inner city, doesn't matter.
Yeah, there's crime's higher, sure.
Right? But if the incident occurred at night or during the day. Lighting, right, your perception of,
Nothing good
Fear.
happens at 2 in the morning.
right?
Well, not on the subway anyway. Unless you're watching Risky Business.
What if it's during the summer or the winter?
Seriously? More crime when it's hotter, right?
Yeah.
So global warming is gonna be a global crime.
And what if Sean had been mugged once before, but it wasn't on a train? That's going to be in his mind. I was mugged once before. Yeah, it wasn't on a train, but you know what? It was 4 guys, and 2 of them stood on either side of me, and they said, "Give me $5."
I'm reliving that one.
Yeah, right.
And that's why I'm carrying that gun.
And that's why I'm carrying that gun. And,
I had a case, not exactly like that, obviously, but somewhat like that a few years ago, where the victim, or the defendant, I should say, shot a guy in the head who was trespassing on her neighbor's property. And as it turned out, when we got to sentencing, she had been the victim of a sexual assault walking home from school 30 years before. And after that, the gun that she used to shoot the guy, she slept with that under her pillow every night. Is the sexual assault relevant? Yeah, I think so. It might not, it might not actually get admitted, but yeah, because it goes to her frame of mind about whether this guy's attacking her, whether she needs to defend herself. Yeah.
so, in this particular case, right, Bernie Getz was acquitted. Shot 4 guys.
4 guys.
And
Boom,
he,
boom, boom, boom,
not a
boom.
scratch on him.
Yeah.
And jury found him not guilty. And look at the instruction that the judge gave, right? Or somebody can be justified in using deadly force in defense of the person. They must have reasonably believed that he was being threatened with deadly physical force. What then is a reasonable belief? Determination of reasonableness must be based upon the circumstances facing the defendant or his situation in terms encompassing more than the physical movements of the potential assailant or assailants. These terms include any relevant knowledge the defendant had about the person of persons. They also necessarily bring in the physical attributes of the person's involvement, including the defendant. Furthermore, the defendant's circumstances encompass any prior experience he had, which would provide a reasonable basis for belief that another person's intentions were to injure him, or that the use of deadly force was necessary under the circumstances. A person may be said to reasonably believe that deadly physical force is about to be used against him if a reasonable person in his shoes, that is in the same circumstances and situation that he faced, would so believe. In other words, in this case, you must scrutinize the reasonableness of any belief the defendant claims to have had by reference to a hypothetical reasonable person who was transported into the subway car on December 22nd, 1984, and who faced the exact situation which confronted the defendant.
And then it starts getting interesting. Is it a reasonable person? I mean, this is not evidence law, but is it a reasonable person? Is it a reasonable white guy like Bernard Getz? What about a reasonable, South Asian woman who had poor language skills and who'd been mugged before, right? You'll see when you get to, if you do employment discrimination law, whether something is a hostile environment has to be interpreted in not just a reasonable person, but a reasonable woman of color, whatever, who was subject to the alleged harassment or whatever, and so gender and life experience to some degree matter. You don't just put a reasonable person where you amalgamate everybody in society. Anyway.
And here in California, you wouldn't get that instruction.
And you might not in New York either.
Yeah, not now, right? And so if you're a prosecutor, do you want to narrow the reasonableness, the reasonable person?
The prosecutor of the guy that did the shooting, right?
Yeah, you're prosecuting, yes. You want it to be a white guy faced with 4? Nope.
You want a reasonable
You want-
American resident.
And that's kind of the way our instructions read now. And so I know whenever I had a self-defense claim by the defendant, I always told the jury, you're the reasonable person. You never asked him to stand in the shoes.
No, that's wrong.
You can't do that. So you don't say you stand in the shoes of the defendant, but they're the reasonable person, right? There's plenty of case law that says jurors are the reasonable person. Okay, so each of you then independently, right? If you were approached by 4 black guys, would you shoot them? Would you shoot if 4 white guys came up to you? Right? Each one of you have to assess it from your own life experience, given the facts that you know he faced. Right? And maybe the evidence will come out that he was told this guy was coming out to get him like Arnold was. Right? Okay, and when somebody came and told you that, how would you react? Right? Or maybe he knew that these guys had committed this crime before because he had seen them.
Wasn't there some indication of that?
Yeah. So
That like he put himself there because he wanted to have a confrontation with the guys? I don't remember.
yeah, there was some of that. So right, what you want to be able to do is, given whatever facts are presented to you, you want to be able to just kind of use your own logic and your own common sense, come up with a reason why those facts would be relevant.
So remember our rule statement, right? Does something have a tendency to make it more or less likely that a fact that matters is true? And you don't have to use that particular formulation. Put it in your own words, but that's the basic idea.
Be careful. We see it every year. Be careful about adding facts that aren't there. Okay? Just analyze what's given to you. Okay? And don't be so caught up with, well, this isn't a good reason. Okay, that's fine. Is it a reason? Does it make this fact more or less probable? Okay, that's what we're looking for. When we're looking for a relevancy analysis, we're looking for minimum tendency, right? You'll make your money on analyzing the other rules and analyzing 403. Okay, that's where you really have to put the work in. We're not expecting you to put a whole lot of work into relevancy. You should have
Because there's usually some other stuff.
yeah. You should be able to articulate pretty easily that this is relevant or not. Okay? And don't be shy and bashful and talk about what we're talking about. If we're talking about sex, if we're talking about race, if we're talking, put it out there. Right? Don't try to be politically correct or say, well, maybe this goes to a hate crime. We all know why you thought that, right? Because race was relevant, right? But he wasn't charged with a hate crime, so don't justify having to talk about race. You're gonna have to anyways. You're gonna have a case at some point in time where race is an issue. Okay, and you're gonna have to talk about it, right? And you may be, I know I always was, the white guy in the room talking about race. Right, let me tell you what the black people think about this, right? Let me tell you what the Hispanics think about this, right? Well, I had witnesses that presented that evidence and then I got to argue it, okay? But sometimes that's just part and parcel of your case. So don't be afraid to, you know, to say what's there.
And this isn't this is an evidence class, not a trial advocacy class, but when are you first going to talk to the jury about race, if race is an issue? During voir dire. You're going to bring it up. You have to bring it up. Get the jurors comfortable and get them talking about it. Because you know they got thoughts about it, right? And you want to know what those thoughts are. But you're never going to find out if you don't bring it up. So,
And you'd be surprised how often, I don't know, I am. Do you want off jury duty? I've had so many idiots. Oh, that guy's Hispanic. I think he's guilty. There you go. Okay, you're just being an idiot. Probably, you know, because they know that's a sure way to get off.
and it is.
You know,
That works.
they just say it and they go on.
They'll also it might get you, the judge making an example out of you.
Yeah.
And calling you a liar. Or something like that.
But you'd be surprised, at least in the criminal world, right? We talk about, you know, motive being a big thing, and insurance being a common motive. Race is a very common motive in crime. Just is. You know? And, they're all idiots, and they tell you what their motive was, right? There's a case going on right now, right, where some guy went to kill a guy in an auto zone out in Desert Hot Springs. Trial just started, right? And he told everybody, "I'm going over there to get me a black guy." It's not the word he used, but
He literally said that.
and then said it again while he was fighting with the black guy. You know,
Fortunately, he did not get him.
yeah, great case. The black guy fought him back,
Yeah.
and he ended up shooting himself.
Yeah.
You know, because he's
It's not a good look if you're trying to kill somebody to shoot yourself.
But you know, they will say these things, right? You know, there's that show, you know, America's Stupidest Criminals. They are stupid, right? And they will telegraph just these things. So, all right.
So, work on those rule statements, because I don't know that anybody had one that you're going to be happy with by the end of next semester.
Yeah.
Okay?
Don't look. These statutes get longer and longer. If you think you're just going to memorize the statute, it's going to be hard. Okay, they get very long as we go forward.
So relevancy, two pieces, boil it down, learn it, know it, live it. Make it something you can write down succinctly, quickly, apply it, and move on.
And we're going to be adding rules every week going forward. So don't wait till next week to say, oh, I think now I need to come up with a relevancy rule statement. You know, do it now, get it out of the way, because next week you're going to need a 403 statement.
And next week is one of the fun things. 403 is really fun.
Yeah.
In contrast to this week, where it was either it's relevant or it's not, 403, we spend a lot of time talking about how relevant is it, and contrast that with how unfairly prejudicial or consuming time it is, or confusing the jury. Okay, so today it was just a qualitative. Yes, no. Next week, it's a no. Quantitative this week, qualitative next week. Sorry. You know what I meant.
I know exactly what you meant. I thought you said it right. All right, guys, that's it for tonight. Next week we're staying late. So you know.
Yeah, that's no way we're getting that over here. But seriously, spend some time on the rule statement, right? Boil it down. You will appreciate it later. I promise. And at least one of you will not listen to me.
It sounds like if we keep beating this dead horse, we see it every semester. somebody's not gonna have a good relevancy statement on their file.
Seriously. I don't get it. It's like one of the basic building blocks.
And you think, how's that possible? You guys just told us.
Yeah.
Yeah, how is it?
Everybody got one of these? Okay. Seminars, Saturdays, 8 AM to 5 PM. Okay? So, no.
All right, guys.
Thank you.
Now I gotta go get some sleep.
Yeah.
Yeah.